Hi, this is Ellen with the Good Girl's Guide to County Jail for the Bad Girl in Us All with another chapter excerpt, Chapter 12, the court process. Bear in mind it is a process, all right? That's why most people get lawyers, if they can afford them, or they don't get in trouble to begin with. But hey, not all of us have that luxury. So for the ones that are getting in trouble, who may not have been caught, just beware that you can't go to court and do everything in one day, all right? Like, that's not how it works. So you're going to have to track your entire case through everything from your arrest to your arraignment to your preliminary hearing to your preliminary hearing. Then you're going to have to do pretrial hearings and motions if you end up thinking that your case is going to trial. You may have a jury trial, you may have a court trial, you may be able to appeal. But the fact is, it is definitely better to fight your case on the outside. Anybody would agree with you, because you can wear your own clothes, you can do your own thing, you can show up, you can be early, you can be late, you can go home in a car, you can go home on a bus. If you are in jail and in a pre-conviction state and you're going through the court system process as well, you will be up very early in the morning. You will be out to court probably by 5 in the morning, 4 in the morning sometimes. So there will be a lot of waiting before the court even opens, and you will be chained and shackled and maybe even tackled. You know what? You may be shackled and tackled. So, but we cover that in my next chapter, deputy rules not to be mistaken for the law. So that's chapter 13, the bad luck one, right? Because God forbid you run into some bad luck in there. So interview with the lawyer and lawyer direct are two little subsections in this chapter which go over first-hand advice and knowledge from criminal defense attorneys in particularly Southern California that I talked to or interviewed or plagiarized. No, I didn't plagiarize them, but anyway. Okay, so, because that would be criminal. Bad girl, don't do that. Anyway, so your arraignment date is usually within 72 hours, 3 business days of your arrest. So if you're arrested on the weekend, that 72 hours includes 24 hours of weekend time. So, that's something they don't really tell you either. Anyway, back to the excerpt. By now, you've already been processed, classified, and stupefied. By now, you've had time to sober up, detox from your high, or just catch up on some sleep. At your arraignment, your charges are laid out in court for you and your public defender or private attorney. You are informed of your constitutional rights. You have the right to a complete copy of your discovery at this point, but your legal counsel will need to black out and redact some of the information in it before you even get a copy of it yourself. You may be arraigned in front of a video version judge rather being transported to court, right? So, I'm telling you, you don't want to go there. I'm going to skip ahead. If your case is a misdemeanor, you will be able to plead guilty, not guilty, or no contest. If you are in custody, bail will be set at this time. You should have ordered a copy of your discovery by now and be doing some of your own strategizing on how to get yourself off the hook. Pre-preliminary hearing is where you and your public defender or private attorney will learn about the evidence that has already been collected by the arresting officer and the case now on the district attorney's desk. Do not be surprised if you have not seen any of the evidence against you at this point, whether there's video surveillance of you or other inescapable evidence in the district attorney's hands or not. They are not going to be in a hurry to render your case to the council. Now, for those who thought that was really strange, that's my version of slow-mo. You've heard when you go on to vacation that, there's Jamaica time and there's mountain time and there's this time and there's beach time and whatever else, right? So there's jail time and court time, and that's really slow. It really is. So Don't be a victim to the system. Forearmed. Forearmed is the better way to do it, because forewarned and forearmed, free arms, that's what I'm saying. Okay. The other part is, let's see, once you get to pretrial hearings and motions, this is a hearing held to settle the case without going to trial. If you've made it this far, you may be on the brink of accepting there may be less of a plea and more of a conviction, and a whole lot more time in. Once a defendant is held to answer, there is a second arraignment in the trial level court of the Supreme Court. Thoughts of state time may be drenching you with sweat. Your discovery is traded back and forth between the prosecution and defense attorneys and may contain photographic, auditory evidence against you, police reports, forensic test results, other unsavory exploits you may not even be aware of yet. If you have a co-defendant, it may shed light on what they may have divulged to authorities. There is plenty of debate about whether to have a judge or jury decide your case. Your lawyer or public defender may use strategy to prevent you from being held to answer or file a motion to suppress evidence that may have been obtained in less than legal ways. There is often a desire to settle the case without going to trial. You may be offered a deal that the district attorney claims will get worse if you don't take it. If your plea was not guilty at your arraignment or your preliminary hearing, you may change it at this hearing to guilty or no contest and try to get a decent enough deal to end the case. I could just keep reading, except there'd be no point for you to get that book with her. You have to read it.